A new immigration law has just been approved. But the real question isn't what changed. It's who benefits first, and who may need to adjust next. The new immigration law didn't arrive with immediate clarity. It was approved according to reports, but many details only started getting attention afterward. And that's where confusion began. Not because the law is unclear, but because headlines moved faster than explanations. The approval through U.S. Congress signals a policy shift, but not an overnight change to immigration status or eligibility. Experts say most immigration laws take time before people feel real effects. The early phase is usually about guidance, interpretation, and how agencies begin applying updated procedures. What makes this moment important is timing. Immigration systems already handle large numbers of applications, and when a new law is introduced, even small procedural adjustments can influence how cases move forward. Some people may notice changes sooner, while others may see no difference at all. And here's where the story becomes more interesting. According to reports, the biggest impact may not come from new rules themselves, but from how priorities are organized after approval. In the next section, we'll look at what the law actually changes, and why some of the biggest claims online may not match the reality. When headlines first appeared, many people assumed the new law meant immediate and dramatic changes. But according to reports, the practical reality looks more gradual and procedural. The law itself focuses less on creating entirely new requirements and more on adjusting how existing immigration processes are handled. Step by step, the first thing to understand is that eligibility rules for most visas and green cards remain largely the same. Permanent residency categories, family sponsorship structures, and application pathways have not suddenly disappeared. What may change is how cases are reviewed and prioritized once they enter the system. Reports suggest that agencies may receive updated guidance on documentation checks, processing order, and verification steps. This can make reviews more structured and consistent. For applicants, that may feel like longer review times in some cases, especially while new procedures are being implemented. Another important point is timing. Laws approved by the U.S. Congress usually move through an adjustment period. Agencies interpret the law, update internal procedures, and only then do changes become noticeable to the public. This means most people will not see immediate differences in daily life or ongoing applications. The key takeaway is preparation rather than reaction. Keeping documents accurate, following official updates, and understanding that procedural changes take time can help avoid unnecessary stress. According to reports, not every group will notice the effects of a new immigration law at the same time. In most cases, the first people who may see clearer outcomes are those already moving through active immigration processes, especially where procedures are being clarified or streamlined. Step by step, this often begins with applicants whose cases are already well documented and complete. When agencies introduce clearer review guidelines, applications with consistent records and fewer verification questions may move more smoothly through the system. This does not mean special treatment. It simply reflects how organized files are easier to process under updated procedures. Another group that may benefit early includes applicants in categories where processing backlogs have been a concern. According to reports, administrative adjustments sometimes aim to improve efficiency in areas where delays are common. If review steps become more standardized, some cases may see more predictable timelines. Employment-based applicants in certain situations may also notice clearer outcomes first. When requirements and documentation expectations are defined more precisely, employers and applicants can submit more complete filings from the beginning, reducing the need for follow-up requests. It's important to understand that benefit in this context usually means clarity and consistency, not faster approval for everyone. Many applications will continue moving at normal speeds, especially during early implementation. The practical takeaway is preparation. Accurate records, complete documentation, and timely responses to requests can help applicants move through updated procedures more smoothly. According to reports, while some applicants may experience smoother processing, others may notice small adjustments in how their cases are reviewed. This does not necessarily mean negative outcomes. In many situations, it simply reflects updated procedures being applied more consistently. Step by step, applicants with complex travel histories or gaps in documentation may notice these differences first. When review standards become more structured, officers may take additional time to verify information that was previously reviewed more quickly. This can lead to requests for clarification or slightly longer processing times in some cases. Another group that may notice adjustments includes applicants whose information has changed across multiple filings. For example, differences in address history, employment details, or travel records may require additional confirmation. Reports suggest this is part of improving record accuracy rather than introducing new restrictions. Family-based or status adjustment cases may also feel procedural changes earlier because they already involve deeper review. When updated guidelines are introduced, these applications often reflect the changes first simply due to the level of detail involved. The important point is preparation, not concern. Keeping records organized, reviewing forms carefully before submission, and responding clearly to any information requests can help prevent delays. In many cases, the adjustment is simply about ensuring files are complete and consistent. Another important part of this update involves processing priorities. According to reports, when a new immigration law is approved, agencies often adjust the order in which certain cases are reviewed. This does not usually change eligibility rules, but it can influence timelines. Step by step, agencies may first focus on categories that the new law highlights. If the law emphasizes certain visa types, family categories, or employment needs, those applications may receive earlier attention. This can result in faster movement for some groups, while others continue under standard timelines. At the same time, internal workload balancing may shift. When resources are redirected to priority cases, non-priority applications may experience slight delays. This is a common administrative adjustment rather than a signal of rejection or restriction. Another factor is transition timing. When guidance is updated, officers may take extra time to apply new review standards correctly. During this adjustment period, processing speeds can vary from case to case. Over time, reports suggest timelines usually stabilize as procedures become routine. For applicants, the practical response is planning ahead. Submitting complete documentation early, monitoring official processing updates, and avoiding last-minute filings when possible can reduce stress if timelines fluctuate. The key takeaway is that priority shifts are about allocation of resources, not about changing who qualifies. Understanding that helps set realistic expectations. When it comes to green cards and visas, reports suggest the main changes are not about new eligibility rules, but about where review attention may be focused. In simple terms, the process itself remains familiar, but certain details may receive closer and more consistent review. Step by step, this begins with documentation. Applications for green cards and visas already require proof of eligibility, residence, employment, or family relationships. According to reports, officers may now spend more time confirming that submitted information matches previous records and supporting documents. This is described as a verification focus rather than a change in qualification standards. Another area involves consistency across cases. Agencies such as U.S. Citizenship and Immigration Services may apply updated guidance to ensure similar cases are reviewed in similar ways. For applicants, this can mean clearer expectations, even if reviews sometimes take longer during the adjustment period. Reports also suggest that travel history, Address records and timelines between applications may receive more structured review. Again, this does not mean new restrictions. It simply reflects an effort to make decisions more uniform and documented. The practical takeaway is preparation. Keeping records organized, ensuring forms are accurate, and submitting complete documentation from the start can help applications move more smoothly under this review focus. Family-based immigration is another area where attention has increased after the approval of the new law. According to reports, sponsors are watching closely because these cases already involve detailed review, and even small procedural adjustments can affect timelines. Step by step, family-based cases usually begin with verifying the relationship between the sponsor and the applicant. That part has not changed. What reports suggest is that officers may now focus more carefully on documentation consistency, residency history, and financial information to ensure files are complete before moving forward. Because family petitions often move through multiple stages, any added verification step in one stage may extend overall processing time slightly. This does not mean new restrictions are being introduced. In many cases, it simply reflects a more structured review process designed to reduce errors later in the application. Sponsors may also notice increased emphasis on accurate paperwork. Matching information across forms, keeping address and employment details updated, and responding clearly to requests for additional information can help avoid delays. The overall message remains steady. Family-based immigration pathways continue to operate as before, but organization and preparation may play a larger role in how smoothly cases progress. Work and employment-based immigration categories are also part of the discussion. According to reports, the changes here appear to be administrative rather than structural. In simple terms, the types of work visas and employment green cards remain the same, but how cases are reviewed may become more standardized. Step by step, employment cases usually begin with employer documentation. This includes proof of job offers, business details, and eligibility requirements. Reports suggest officers may apply clearer review checklists to confirm that applications are complete before moving them forward. That can reduce confusion, but it may also mean more careful verification at the early stages. Another possible adjustment involves coordination between agencies that review employment records. When systems share information digitally, officers may confirm data such as company filings or prior visa history more closely. This does not introduce new requirements. It simply reflects stronger record matching. In some cases, updated processing priorities may influence timelines for certain job categories. If the law highlights specific workforce needs, those categories could receive earlier attention. Others may continue under standard processing order. For applicants and employers, preparation is straightforward. Submit complete documentation, ensure job details are accurate, and keep records organized. Clear filings reduce the need for follow-up requests and help cases move steadily. The key point is that employment pathways remain open and structured. The changes appear focused on consistency and verification, not limitation. Since the announcement, a lot of discussion has appeared online. But according to reports, some of the most widely shared claims are based on misunderstandings rather than actual changes in the law. Clearing this up helps people focus on preparation instead of confusion. Step by step, one common misunderstanding is that the new law immediately changes everyone's immigration status. Reports do not support this. Most eligibility rules remain the same, and ongoing applications continue under existing categories. The adjustments being discussed are mostly about how cases are reviewed, not who qualifies. Another misunderstanding is that approvals or denials will suddenly increase. In reality, experts say administrative updates usually aim to make decisions more consistent, not stricter. A more structured review process can sometimes feel slower, but it is not designed to penalize applicants who meet requirements. Some online discussions also suggest that travel or employment rules have been completely rewritten. According to reports, this is not accurate. Existing expectations still apply, and most applicants will not notice major changes in daily life. The practical response is simple. Focus on verified information, review official updates carefully, and avoid reacting to unconfirmed claims. Keeping documents accurate and organized remains the most effective way to move through any immigration process smoothly. After a new immigration law is approved, changes rarely appear all at once. According to reports, implementation usually happens in stages, which is why many people may not notice immediate differences. Step by step, the process often begins with agencies reviewing the new law and updating internal guidance. Officers receive instructions on how procedures should be applied, and systems may be adjusted to match updated requirements. This phase can take time, especially when multiple departments are involved. Next, the changes start appearing in specific types of cases first. Applications already in progress, renewals, or new filings submitted after updated guidance may reflect procedural differences earlier than older cases. This can create the impression that rules are changing unevenly, when in reality, the system is simply transitioning. Another reason changes appear gradual is training and consistency. According to reports, agencies aim to apply new procedures uniformly, which requires adjustment periods before timelines stabilize. During this phase, some cases may move faster, while others take slightly longer as reviews become standardized. For applicants, the practical approach is patience and preparation. Keeping documents organized, following official updates, and understanding that implementation takes time can reduce unnecessary concern. The key point is that gradual change is normal in immigration policy. It allows agencies to adjust processes carefully rather than introducing sudden disruptions.